Thank you very much. My name is William Large. I'm the president of the Florida Justice Reform Institute. It is a tort reform or civil justice reform group that was started in 2005 by a lot of the member companies here in this room, by the Florida Chamber of Commerce and other groups, to act as a standalone group to organize the business, the insurance, and the healthcare community against the trial bar. At any given time, we're working on 3 to 5 issues, and in the past, we've worked on a panoply of issues, including workers' comp reform, products liability reform, joint and several liability. What I want to talk to you about is a series of reforms that I would like to see get passed in 2015, and tell you a little bit about those issues and a little bit about what is needed to get those issues across the finish line. We've got a great panel here today. We've got Harold Kim from the Institute for Legal Reform. Harold is a lawyer in Washington, D.C. He served on the Senate Judiciary as staff counsel to Arlen Specter and Orrin Hatch, and has a lot of D.C. contacts. And the Institute for Legal Reform is basically the 800-pound gorilla of tort reform in the country. Harold's job is to follow these issues in 50 states. So he also obviously focuses on the problem states, and unfortunately, Florida is known as a problem state nationwide. And it's very interesting that we have someone from a national perspective that is so well versed in what is wrong with Florida because of Florida's numerous problems. And he's going to talk to you about how Florida has been identified as a problem state in terms of third-party bad faith litigation from a national perspective. Next, we have David Quorum from the Insurance Research Council. And one of the things about advocating for tort reform that is often very difficult is legislators want quantitative proof. They want to know, what does this really cost my constituents? And as we've advocated for third-party bad faith reform or fair settlement reform in the past, many legislators have tried to stop us cold and say, well, prove it, show us the numbers. Well, David authored a very interesting report that came out this summer that quantified exactly what this problem costs in terms of Florida consumers, and it is essentially a tort tax that has now been quantified. Our final speaker is Andy Connell with the law firm of Litchfield and Cabo. And Andy is a real-world litigator who is in the trenches day in, day out on a lot of these tort fights, but in the courtroom. And he's going to tell you a little bit about something that we call accuracy in damages or phantom damages, and how the plaintiff's bar inflates medicals in bad faith cases and other types of lawsuits through use of letters of protection and abusing the collateral source rule and other things that artificially inflate damages. So without further ado, I'm going to introduce Harold and let Harold talk to you about third-party bad faith in Florida and how it's been identified by national commentators as a problem.
Thank you, William. Appreciate the comparison to an obese primate. Thanks to the Florida Chamber, David Hart. I don't think Mark Wilson is here, but to everyone for having this event. It's a very impressive event, and it's good to get in-state business leaders together to talk about these very critical and important issues affecting the insurance industry. As William mentioned, my name is Harold Kim. I'm the Executive Vice President at the U.S. Chamber Institute for Legal Reform. What I'm going to do is talk a little bit about ILR before I talk about the problems of bad faith litigation in this state, the economic impact and the consequences of such litigation, and then finally to talk about what the solution would be and hopefully considered as part of this legislative session. So first, ILR, or the Institute for Legal Reform. We were established in 1998. We are a separate affiliate of the U.S. Chamber of Commerce, and we are solely dedicated to ensuring that our civil justice system in this country is fair, balanced, and also something that does not become a playground for the organized plaintiff's bar. We operate in the hallways of Congress. We will advocate with senators, members of the House, but also in state legislative bodies all throughout the country. And frankly, when you look at tort reform over the course of the last 5 to 10 years, the action has been at the state level since Congress continues to be dysfunctional. We boast a very diverse membership. So, of course, we represent those in the P&C industry, but we represent manufacturers. We represent the financial services industry, telecom companies, virtually any company out there that has potential legal liabilities. And certainly here in the United States, which is the most expensive tort environment on the planet, is something that is our mission and our charge to advocate for changes on a reform level. So why bad faith litigation? Why here in Florida? Bad faith, the concept of bad faith is a rule of law which basically holds insurers honest. And it is recognized in every single state. You're supposed to deal fairly with your insureds. And that's a pretty good rule of law and something that has its origins deep in judge-made law and common law. And it allows an insured who thinks that they've been on the wrong end of a deal to seek damages beyond the limits of a policy. Now, there's a variation or a strain of bad faith litigation, and that deals with third-party bad faith litigation. And that gives the ability of an injured party, somebody who was wronged by a tortfeasor, to stand in the shoes of the insured to seek damages for bad faith actions or alleged bad faith actions against the insurance company. It is outside of the mainstream. There are only 7 states, including Florida, that recognize this type of extra contractual liability. But I will tell you, Florida is the worst of the worst. It is third-party bad faith litigation on steroids. And what do I mean by that? It's abusive. It is really abusive. Some would say frivolous. Some would say damning, in the way that the plaintiff's lawyers have manipulated the system in a way that completely goes beyond traditional concepts of insurance. It's a contract. As an insured, you pay premiums. You get covered if there is a covered loss. Well, in this state, it doesn't matter if you're minimally insured or not. As long as you can play into the plaintiff's lawyer's games, you will be potentially overinsured, even though your contract doesn't set it out. We have unclear standards and bad case law. Florida Supreme Court, certain appellate courts come up with these wacky tests that really don't provide a whole lot of clarity. We as lawyers want to know what the rule of law is. We use words like stare decisis and precedent. Well, that's not really the case in this state. And it becomes a problem because the plaintiff's lawyers, a core group of them, have manipulated the rules to their advantage and to your disadvantage. And there's the unholy trifecta. These cases come up where you have clear liability, where you have low limits on the policy, and you have a catastrophic injury which is not captured within the damages that are being alleged and that is being covered by the insurance policies here. That's a picture of Dale Swopes. I don't know if you know who Dale Swopes is, but he's probably one of the most preeminent plaintiff's lawyers in bad faith litigation in this country. He's very active in this state. He seems to be a nice dresser, I suppose, but he's made a lot of money off of this. And it is just unseemly and something, again, that is predicated on abusive litigation. And what do I mean by abusive? Well, their whole game is to get the insurance companies to say no. You get a settlement demand with some pretty ridiculous terms. They want to see your internal claim files. They give you 25 days to respond to a settlement demand, and then they say, well, you haven't responded within that time. It's very difficult as a claims adjuster to go out there and figure out what happened in a multi-car accident or in a certain catastrophic event. And it's all about getting the insurance companies to say no. In fact, I wouldn't be surprised if Dale Swopes would be asking for your second-born child as part of any settlement terms. Joking. It's a joke. Trying to keep it light here. There are consequences to this. Yes, it is abusive, and we're going to hear a lot more from David as to the dynamics as to how this affects total claim costs in this state. And it is a terrific, terrific piece of economic research that I assure you we have been and will be using with policymakers in this state to press for the case for reform. But let me also talk about a broader state-by-state cost study that was done by the National Economic Research Associates, or NERA. We had commissioned this study back in 2011. They had done a state-by-state assessment of the tort tax. The tort tax being higher insurance premiums, litigation costs, paying for lawyers, discovery. This stuff costs money, and it costs a lot of money in this state. In 2011 alone, it was quantified that the tort cost totally in this state was $15.3 billion. And the study concluded that there would be a positive impact in reducing these tort costs in this state from general legal reforms, not specifically to bad faith, not specifically to a certain bill, but elevating your legal system, your legal climate to other states in the nation that have better legal climates with better and lower tort costs. And what the study concluded was that the state of Florida, in terms of making broad-based legal reforms, could realize a savings of $2.83 billion annually. And if this isn't a tort tax, I don't know what else is when it comes to the amount of total costs to litigate cases in this state. The nearest study also quantified a job increase anywhere between 0.73 to 1.98 from realizing legal reforms. And when you compare this to BLS, or the Bureau of Labor Statistics, numbers, we're talking about an increase between 59,000 plus to 162,000 jobs per year. And that's a pretty significant number for a state like Florida. And of course, I mentioned the IRC study, and we'll hear more about that from David. So let's fix it. We have an opportunity with a pro-business governor in the governor's mansion in Tallahassee, with Republican majorities in both the House and the Senate, to advance a very simple piece of legislation called the Fair Settlement Act. This would give insurance companies a 45-day safe harbor to tender their policy limits upon receipt of a written demand from their insured, as a condition preceding to any third-party litigation matter. In other words, you guys get relief. You have a safe harbor. And this really mitigates the gamesmanship that's been going on out there. Third-party bad faith litigation hurts the Florida legal climate, and I've shown you the economic numbers. It is legal reform, but let me also reemphasize, it's also tax reform, because of the tort tax that every Floridian has to pay in the state through higher premiums, through other costs and goods and services that get passed down, because litigating cases in the state is very, very expensive. And with that, I will pass it on to David.
Thank you very much, Harold, and thank you, William. And my thanks to the Chamber of Commerce for inviting me to participate in this program today. So today, I would like to review with you the findings from a research report that we published in August of last year, where we examined the effects of third-party bad faith on Florida's auto insurance system. And we found, as has been alluded to already, that the third-party bad faith litigation environment here in Florida is, in fact, adding very substantial costs to the auto insurance system in the form of higher BI liability claim payments. So I'm going to walk you through some of the key points of the research and explain to you better how we went about documenting this. So the focus of our research was how it affected the underlying claiming behavior in the system. When you think about bad faith litigation and with auto injury claims, you think about primarily, or initially at least, the direct cost of bad faith litigation, and the costs of those lawsuits, the costs of settlements, and the costs of court verdicts, and the associated litigation costs. But we weren't able to look at that because those costs and those claims are not actually insurance claims, and they fall outside of the normal insurance claim reporting and statistical systems. And there is, to our knowledge, no method or system for collecting across the industry how much bad faith litigation is actually occurring and what the costs of those claims in terms of settlements and verdicts are. What we looked at was the indirect cost, because another way that bad faith litigation affects the system is that it's a major change in the incentives for engaging in filing BI liability claims in the state. So it's a major incentive that affects both potential claimants and it affects their attorneys. So that was really the focus of our analysis, was how the bad faith environment in Florida motivates claimants and their attorneys to file more and more BI liability claims. So what we did was we compared Florida's claims experience with that of 3 other major no-fault states, New York, New Jersey, and Pennsylvania. They have some things in common with Florida. They're large states. They're no-fault states. But one thing that's very different about those states is that they do not have the same kind of bad faith liability litigation environment that Florida has. Florida has a statutory cause of action for claimants to file bad faith lawsuits. And in New York and New Jersey and Pennsylvania, as in most other states, they rely primarily on administrative mechanisms working in the insurance department to investigate allegations of bad faith. And there are penalties and fines involved whenever bad faith is found to exist. But for the most part, claimants do not have the ability or authority to file a third-party lawsuit against a third-party insurer. We also compared Florida's claims experience with the claims experience for the country as a whole, and I'll explain a little more about that. There are three primary measures that we are looking at. The first one is what you probably know as loss costs, which is the average claim payment in the state, averaged over all of the insured vehicles in the state. So we looked at BI, average claim payment per vehicle. We also looked at claim frequency, and we also looked at claim severity. So we compared Florida's claims experience on these measures over time with the experience in the three states that I mentioned, and then also with the country as a whole. Okay, so this first chart looks at the average claim payment per insured vehicle at three different times, 1985, 1995, and then 2013. And as you can see, in 1985, Florida's average claim payment per insured vehicle was about the same as New York and Pennsylvania. New Jersey was clearly the outlier here, and I'm sure even here in Florida you've heard about the problems that New Jersey has been experiencing. But compared to the other states, New York and Pennsylvania, Florida was about the same in 1985. Jump ahead 10 years, and you'll see that Florida's average BI claim payment per insured vehicle almost doubled, but it did so in New York and in Pennsylvania as well. New Jersey, as a result of efforts to control costs in that state, legislative reforms that were enacted over several years, and probably the physical fact that you couldn't go any higher in New Jersey, but claim costs actually fell from 85 to 95 in New Jersey. Then let's jump ahead to 2013, and this is the time period where that is of most interest to us, because in the early part of this time period, around 95 and in the mid-90s, was when it is my understanding that the third-party legal environment really started to deteriorate in Florida. So jumping ahead to 2013, if I can get here we go. As you can see, costs continued to decline in New Jersey. They declined 18% in Pennsylvania. They actually increased 18% in New York. But in Florida, they jumped a very substantial 68% from 1995 to 2013. So while in these other states costs were moderating dramatically, in Florida they were growing very rapidly. Another way to look at these trends is what we show in this chart, where we index every state to 1995. So we start at a common point and then show how costs changed over time in each of those states. And we selected 1995 not because that's when a light was switched on and suddenly everything fell apart, but some legal observers have sort of identified 1995 as the beginning of the period of time when a lot of the case law was coming out about that created and led to the situation that we're in now. So we started with 1995 and looking first at a composite of the three other no-fault states, New Jersey, New York, and Pennsylvania. You can see that costs starting from 1995 jumped a little bit, or dropped and then jumped a little bit, then dropped some more. But at the end of the period, in 2013, they were pretty much about where they were at the beginning of the period in 1995. Countrywide, we saw a very similar trend. Cost kind of leveled off after the year 2000, and then, but at the end of the period, 2013, they were pretty much the same as they were before. But when you look at Florida, it's a very different story. It's a very different picture. Starting around 1995 and really picking up steam after the 2000, costs just continued to rise and rise and rise. And it's interesting to look at this too, because as you can see, before 95, Florida was on pretty much the same trend as the other three no-fault states and as the country as a whole was. But around that time period, 1995 and shortly after that, when the bad faith cases started to come out, costs just started to accelerate. Now, when we look at trends like this, one thing we always want to do is sort of deconstruct these average loss cost trends and look separately at claim severity and claim frequency, because it's always really important to know whether you have a claim severity problem or a claim frequency problem. And interestingly, comparing Florida with the countrywide average and with the three-state composite, claim severity for BI liability claims actually fell 39%, whereas in the other states, they rose by 50-60% over the 95 to 2013 period. But where the issue lies is with claim frequency, because in the other states and in countrywide, claim frequency has been declining steadily for BI liability claims, but that has not been the case in Florida. Claim frequency in Florida is rising rapidly, and that is really the kernel that we're looking at, and what is, we think, driving the increase, the additional costs that are attributable to the bad faith claim environment. We looked a little more closely at Florida and the other states with respect to claim frequency, and again looking at 95 and 2013. And again, these are all no-fault states. Florida is unique among the states in that it has a statutory cause of action for third-party bad faith. In 95, Florida was very similar to New York and Pennsylvania. New Jersey, again, was the outlier there. By 2013, very different picture. Florida is clearly the outlier. New Jersey even is the lowest of the states. Now, not all of this may be attributable to the bad faith claim environment, but we do think most of it, if not all of it, is. There may be other factors like low limits, but then Pennsylvania has lower limits than Florida. New Jersey has limits that are 3 times what Pennsylvania's are, but then, as you see here, the claim frequency is the same in those states. We don't see a strong relationship between limits, minimum limits, and actual BI claim frequency or claim costs altogether. So Florida, as a no-fault state, clearly is ahead of any of the other states in claim frequency. And what was really amazing was when we looked at, compared Florida to other tort states, states that don't have PIP benefits. BI liability is the primary means for compensating for medical and other damages as a result of auto injuries. But Florida's BI claim frequency rate is, in 2013, was higher than in a majority of the tort system states around the country, which is just, it's just upside down from what it should be in a no-fault state. So what we wanted to do was estimate as best we could how this is impacting the state in terms of costs. And again, what we see this as, the way that we see this as working is that the potential for receiving a significant verdict or settlement as a result of a third-party bad faith lawsuit is driving a lot of excessive claiming in the system. I mean, you can't get that bad faith settlement unless you file a BI liability claim. So we think that is what is incentivizing a lot of claimants and their attorneys, or maybe it's their attorneys and their claimants, to file more and more BI liability claims. We estimated this based on an assumption that what if Florida's BI liability trend in loss costs was the same as the other no-fault states, and the same as countrywide. In that earlier slide, you saw that from 95 to 2013, that the average loss cost in those other 3 states and countrywide was essentially unchanged. It was the same in 2013 as it was in 1995. Everywhere else but just about except Florida. So if Florida's BI liability loss costs were the same in 2013 as in 1995, it would have amounted to about $79 per insured vehicle in the state. And when you have 10.3 million or more insured vehicles in the state, and I think that's a low number, that comes to over $800 million in 2013 that we think is largely attributable to the bad faith claiming environment in the state. So that's pretty much the summary of our research. So with that, I'll turn it over to our next panelist, Andy.
Thanks, David.
Thank you, David, Harold, and William, and thanks to the Chamber for inviting me. I defend personal injury cases for a living in South Florida, which is a challenging venue for defendants for a number of reasons. One of those reasons is inflated medical damages in personal injury cases. Inflated medical damages in personal injury cases are cost drivers for general liability cases, and as you know, general liability cases are the underlying case that eventually gives rise to the claim of bad faith. Generally speaking, plaintiffs are going to have their medical bills paid for one of 3 ways in a personal injury case. The first way is if they have Medicare or Medicaid. If they have Medicare or Medicaid, this is the good news, the defendants are entitled to a pretrial reduction of the bills for the amount of all Medicaid or Medicare write-offs and adjustments. That's because Medicaid and Medicare are considered to not be collateral sources because they're available to all members of society without having to pay a premium, and therefore you get the pretrial reduction. So Medicare and Medicaid is actually the most favorable way that we currently see plaintiffs having their medical bills paid for in the state of Florida. The next way that some personal injury plaintiffs have their medical bills paid for, past medical bills, is private health insurance. Private health insurance has been interpreted to be a collateral source. Therefore, you're not allowed to introduce evidence of it at trial. The reason it's a collateral source is because you pay a premium for that health insurance. That's the rationale. And therefore, because it's a collateral source and no collateral source evidence is admissible at trial, therefore, defendants have to take only a post-trial set-off for the amounts of health insurance write-offs and adjustments. The significance of that is that jurors often look at past medical expenses when they're using that as a barometer to figure out what they're going to award for future medical expenses and what they're going to award for past pain and suffering as well as future pain and suffering. So plaintiff attorneys prefer health insurance because they get to board a much larger number. They get to board the full billed amount at trial. And then the jury thinks, wow, this is a really big number. This plaintiff must have been hurt really bad. Even though they're not told that the person had health insurance that adjusted it and wrote it down, everybody knows that the billed amounts are not real numbers. But nevertheless, the jury is using that billed amount when they decide how much they're going to award for non-economic damages like pain and suffering. So that's a problem area. It's not nearly as bad as a problem, though, compared to letters of protection. Letters of protection are the worst form of payment arrangements that we see in personal injury cases for the payment of past medical expenses in these cases. It's basically a contract between the attorney, the plaintiff personal injury attorney, and the doctor and the patient, and it's a deferred billing arrangement by which ultimately the doctor treats now and bills now, but gets paid later out of the proceeds from the lawsuit once the lawsuit is either settled or there's a judgment. Now, why would a personal injury plaintiff who has health insurance or who has Medicare bypass that coverage intentionally in order to use an LOP? We see it all the time. There's one simple reason, and that's simply to drive up artificially the value of their claim or lawsuit. And this is just an example of what a letter of protection looks like. It's in writing, the patient signs it, the plaintiff's attorney signs it, and everybody agrees that the doctor is going to get paid out of the proceeds from the lawsuit. There are a lot of problems associated with letters of protection. One is that oftentimes they're used as a vehicle by which controversial and unnecessary medical procedures are performed. We see things like percutaneous discectomies, which is done at an outpatient surgery center. It takes 45 minutes. A wand is inserted directly through the skin. The patient leaves with a Band-Aid on their back. The disc material might be heated up a little bit. A little bit of disc material may be removed, maybe not. There may or may not be pathology. In some cases, you don't even know whether anything was actually done, but there's a bill. And the bills are quite large. You can see an $80,000 bill for a percutaneous discectomy when somebody's in and out of an outpatient surgery center within a few hours with a Band-Aid on their back. And so we see large bills, and we see controversial procedures. The problem is, one of the problems is that the letters of protection invite collusion between the plaintiff's attorneys and the plaintiff's doctors. As part of that, we see in some cases there's a trend that letters of protection are being sold like commodities on the open market to the highest bidder. This is just a simple example of what the cycle essentially looks like. You've got the plaintiff personal injury law firm bringing in the new client. In cases where there is PIP in an auto case, first they send the client, the plaintiff, to a chiropractor to exhaust the PIP. Once that's exhausted, then they send the plaintiff to a physician, a surgeon, who the law firm has a relationship with. And keep in mind that, especially in South Florida, a lot of these surgeons doing these LOP procedures, 100% of their practice is LOP medicine in personal injury cases. So you've got a situation where these doctors are beholden for their livelihood to plaintiff's personal injury attorneys. I think that creates a strong incentive and a strong bias on their part to give opinions that the plaintiff attorneys like, so that the plaintiff attorneys then send them more clients, more patients. So the surgeon sends a letter of protection, the doctor signs off, the attorney signs off on it, the plaintiff signs off on it, they do the surgery, and then they have this artificially inflated bill for this surgery. And that's part of the settlement demand. And the case then settles, as a large number of cases do. The case settles based on that inflated number, that artificial number that was used under the letter of protection to generate an artificially high medical bill. The case settles, but then after the case settles, the dirty little secret is, at that point, the attorney goes back to the doctor, and they've got either tacit or express agreements that they're going to then discount the bill. So after the case is settled based on an inflated amount, the attorney and the doctor work out a lower amount, which is ultimately accepted as payment in full by the doctor for the procedure performed. So there's a windfall. There's a huge windfall to plaintiff's attorneys in this circumstance, and it's absolutely a drain on the system. This is just some testimony from a case where a director of operations at an MRI facility center acknowledged under oath that there are certainly times when, after a case is settled, the bill is then negotiated down and something less than the full billed amount is accepted as payment in full for the bill. And we know as a practical matter it's something dramatically less oftentimes. There are some ways that we would like to combat phantom damages. Some of the ways we're allowed to do under current law, and others we're not. The first one is a straightforward example. That would be an argument where we say that the injury being claimed in the case is not causally related to the accident that's at issue in the case. Maybe the person had a prior accident. Maybe they had a pre-existing condition that ultimately would be the causal relation to the injury being claimed in the case, as opposed to your accident in that case. That we're allowed to argue. The next way that we would like to combat phantom damages, if we are allowed to under current law, is that we would love to make an argument in these cases that in some cases, like some of the examples I just described to you, the treatment is unreasonable and not medically necessary. That might include a situation where even if the plaintiff doesn't have a pre-existing back problem, even if they weren't involved in a prior accident where they hurt their back, we might want to argue, hey, wait a minute, the MRI performed after our accident was totally clean, there was no disc pathology, so this person didn't need an $80,000 percutaneous discectomy at an outpatient surgery center. So this was an unreasonable procedure. It was a medically unnecessary procedure. Well, we're not allowed to argue that under current Florida law. based on the progeny of Stewart versus Hertz, which I'll explain in a little more detail in a moment. And the last way we like to try and combat phantom damages by arguing that the medical billing is excessive and unreasonable. Stewart versus Hertz, one of the issues on the prior slide there, Stewart versus Hertz essentially held that where you have an initial tortfeasor, the defendant in an initial car accident case, they're liable not only, assuming that they're found liable, assuming they're found to be negligent, they are liable not only for the injury caused by the car accident itself, they're also liable for any aggravation to that injury caused by subsequent medical malpractice. That decision in and of itself was not necessarily a bad one, but it's been interpreted and expanded over the years since that decision came out to the point where now, even if a defendant in one of these cases doesn't argue that the physician committed malpractice, even if the defendant doesn't argue that the plaintiff was made worse by the medical treatment, simply arguing that medical treatment was unreasonable or not medically necessary is considered a violation of Stewart versus Hertz now under the more recent case law. So we can't argue. In that example I just gave you where the plaintiff is sent to an outpatient center for a 45-minute controversial procedure that Medicare won't even pay for anymore because it's determined to be not efficacious for the treatment of back pain. In that circumstance, we can't make those arguments. So we're essentially being forced to bring a knife to a gunfight, and the plaintiff is putting up all this evidence about all these controversial procedures, and the minute we try and attack the procedure as being controversial or medically unnecessary or unreasonable, the plaintiff attorney jumps up, aha, Stewart versus Hertz. And then the jury is given an instruction that essentially states that the defendant is liable for all aggravations of injuries caused by subsequent medical treatment. It's very difficult because the jury then believes that the defendant should have to pay for the whole thing regardless of whether it was medically unnecessary or not. So it's a very difficult legal environment right now because of Stewart versus Hertz. It makes it very difficult to defend personal injury cases. One of the things I alluded to earlier was the letters of protection being sold. We're seeing this. This seems to be a trend. It's not in every instance of an LOP, but it seems to be a trend. It's happening more and more, where you have a letter of protection, and at some point, the original healthcare provider who provided the treatment decides to sell it to somebody else, like a commodity. This is just an example of a form where one particular physical therapy center sold their letter of protection, their bill under the letter of protection, to a finance company in Arizona, and it turned out that finance company was run by an Arizona chiropractor. It was sold, obviously, for something much less than the full billed amount in that case, but yet the plaintiff in the lawsuit is still seeking the full billed amount. That's why it's a phantom damage. The healthcare provider had already accepted as payment in full for the treatment rendered something far less than the billed amount, but yet in the lawsuit, the plaintiff is seeking the full billed amount as an element of their damages. So that's why it's a true phantom damages situation. This is an interesting situation here in a case I'm currently defending. This is a hospital bill that was originally produced, of course, by the hospital itself. It showed billed amounts of about $18,708.70. It's a hospitalization where the plaintiff underwent a lumbar surgery. The bill also reflects that the the bill also reflects that the hospital was paid $6,480.70 by someone, and that amount was accepted by the hospital as payment in full for the bill and the services. So the remainder was written off, and the bill from the hospital shows a zero balance. So as it turns out, the orthopedist who performed the surgery at the hospital bought the hospital's bill under a letter of protection. So it was sold by the hospital, and we're not talking about the orthopedist's services. He billed for those separately. We're talking about the orthopedist group who performed the surgery buying the hospital letter of protection bill. They're the ones who paid the $6,480.70. So ultimately what they did was, after they bought the bill from the hospital, they then created their own bill for those same services, that same exact hospitalization. They called it an account ledger, except this time somehow their account ledger for the exact same services provided totaled $53,843.22, up from the $18,708. No real explanation as to why. It just, all of a sudden, the value of the bill seemed to jump up to over $50,000. Then what it appears, based on the bill, what happened next, we believe, is that the orthopedist then turned around and sold the bill again, this time to a finance company for $12,384. So the orthopedist group, we believe, pocketed $5,904, the difference between the $12,000 that they sold it for and the $6,000 they paid for it. And nothing has really happened. There's been no settlement of the case, there's been no trial of the case, but there has been a profit on the part of the orthopedic group by buying and then reselling a bill. And who knows what the finance company is going to do with it now. But it's important to keep in mind that the plaintiff is seeking the full $53,843 at this point. So this is the deposition testimony in that same case of the medical billing custodian of the hospital. And that person was asked, do you have any idea how the orthopedic group would have come up with this account ledger, the $53,000 bill I described for you? Answer, no. Do you have any idea why the orthopedic group would be sending out a bill for services that were actually performed at the hospital? No. So the next thing we wanted to do after getting that testimony was we subpoenaed the billing manager of the orthopedic group. We wanted them to come forward and explain what's going on here and why are you raising the value of what should be an $18,000 bill to $53,000 and then reselling that bill at a profit like a commodity. So we subpoenaed that person for deposition. The plaintiff, through plaintiff's counsel, objected. The trial judge sustained the objection, being of the view that we were going too far afield from the issues in the case, even though our position was that these are past medical bills being claimed by the plaintiff as an element of the plaintiff's damages in the case. We thought it was quite relevant. The trial judge disagreed. We now have an appeal pending with the 3rd District Court of Appeal. We're optimistic that we will ultimately get back to the trial court level and be able to depose that person. Here's another interesting scenario that's developing in these cases in South Florida now. We've got the orthopedist in this instance referring the plaintiff for an MRI. And this is an orthopedist who's treating the plaintiff under a letter of protection. It was, of course, the plaintiff and the doctor are a party to. The plaintiff attorney is certainly well aware of it, and the plaintiff attorney and the doctor have a relationship. It turns out that the plaintiff attorney in that case also has an ownership interest in the MRI facility, which the orthopedist referred the plaintiff to for the MRI. You know, when you think about bias, think about the bias of the radiologist interpreting that MRI, knowing, or likely knowing, that the plaintiff attorney in the case has an ownership interest in the MRI center. Don't you think that that radiologist would have a bias to give a report to the plaintiff attorney that the plaintiff attorney liked, so that that radiologist would be sent more films to review from that MRI center, which the plaintiff attorney has an ownership interest in? We feel there's a bias there on the part of the radiologist to overcall abnormalities on films, and we've had instances where we hire our own radiology expert who feels there's no herniated disc, but yet the report from one of these types of facilities says there's a herniated disc. So LOP doctors, they often have not always, but often have 100% LOP practices. Again, I think that makes them beholden to the plaintiff bar. We've seen situations where they have affiliations with the manufacturers of the medical devices they're using during their LOP procedures. Some of them even own companies that distribute those medical devices, so they're making money on all ends of this. And again, there's commodity-style trading going on as well. In my experience as a defense attorney in South Florida, it seems like the trends are getting worse and not better. And it seems like this is the Wild West of personal injury litigation in South Florida. Thank you.
Okay. Well, thank you, Andy. We're out of time here, but folks here in the room, what we need to make these arguments in Tallahassee in terms of changing the mind of state senators and House members is more examples like this. If you have them, please contact me. I'll make my contact information available, whether you have good examples with letters of protection, good examples of abusive practice, and likewise fact patterns where the plaintiff's attorney has intentionally set up the insurance company for a subsequent bad faith cause of action where you're paying far greater than the policy limits. We have David's data in terms of numbers now, but if we are organized in terms of our messaging and with examples, we have the potential to get this bill across the finish line in 2015. So thank you, panel, and thank you, Florida Chamber, for inviting us today.